I'm delighted to be here to kick off this vitally important subject. It does feel like it's very much the end of the beginning, if not a very long beginning, and there's now some serious work to be done. And in the next 20 minutes, I'm going to just paint the scene a little bit in terms of what could happen next. I'm not able to predict precisely what will happen next because that'll be down to the government, as the Airport Commission's report makes quite clear. And it really is all about grasping the nettle, because the time has come to do that. And I think the first point, though, is that it's important to bear in mind that it's not just about the planning process. There's a much bigger context here, which is what Sir Howard called in his report the key supporting policies. So what is that wider package and how will that be delivered? And then in terms of the planning process for the runway-related development, there are the two choices, which you've all heard about, which I will tell you a little bit more about in the next 20 minutes, and what are the key differences between those two routes, and what are the kind of factors that government will take into account in discussions with Heathrow Airport and others in terms of choosing which should be the right process for this project. So if you look at the recommended wider package of measures, it's obviously... I didn't mean to emphasise the van and night flights quite like that, but anyway. But you can see that there are all sorts of things that go beyond the planning process for the new runway and all the related development. All the things set out there, a legal commitment either in a national policy statement or actually in legislation not to have a fourth runway. There's obviously the whole issue of air quality targets we've heard about, a proposed noise levy, possibly an independent noise authority, the ban on night flights, possibly air congestion or access charge has been mooted, and legally binding noise envelopes as well. That's not it. There's another page of them. Look at these. Possibly a community engagement board, maybe a joint oversight board. I thought the most interesting one, actually, was the dedicated delivery body that the Commission mooted. Obviously has parallels with the Olympic Delivery Authority, and actually I think the kind of message I want to give is that this project is as big as the Olympics to bring off, I think, and could well require something like an ODA to achieve it in combination with the airport and with government and with everyone else that's going to be involved. You've got surface access improvements, you've got airspace change, you've got the wider community package that's been suggested, and last but not least, a reform to policy on public service obligations has been suggested so it can operate on an airport-to-airport basis. So a huge, bigger context here, which has to be taken into account in thinking about the correct planning process for the actual development that would be involved in a third runway. Now, in terms of delivering that wider package, it's a hugely complex task, and this is what government is now beginning to think about. They quite rightly need to take a number of months to read the report and to consider what is the best way forward. And there will obviously be discussions between government and Heathrow Airport particularly, but there are also many other bodies involved, as we've been hearing the last couple of days. I've listed the key ones there. Hopefully I haven't missed anybody out. But where will this lead? We've been told by the Secretary of State, and as we heard from George Osborne yesterday, there will be an announcement in the autumn, which could be 20th of December. That is still autumn in Whitehall seasons. And then what might happen then? There could well be some initial House of Commons vote on a motion or otherwise. What might happen then? Well, there are lots of choices open to mandarins and politicians. There could be a green paper. We don't seem to see those very often nowadays. Certainly in the last 20 years, or 25 years, we tend to go straight often to white papers and command papers. Might there be some DFT consultation before there's any decision announced, definitely to proceed with the Commission's recommendations in one form or another? A paving bill. I think that is a real possibility. Paving bills are used occasionally to pave the way for a new policy area. We had one on high speed too. And certainly if, for example, the government's attracted by this idea of having a separate delivery body, you could quite see a paving bill providing for an ODA-type body to be set up early doors to really get the project up and running in partnership with Heathrow Airport. Now, I think there could well be later, following on from that, there could be a civil aviation bill to deal with all those wider policy issues I've just touched on, the noise issues and compensation relating to that and the levy business. I think this is what the Commission call a programme bill in their report. And then finally, you can have all of these public policy issues put into a hybrid bill, the other half of which is dealing with the actual development aspects, which I'm going to come on to talk about. So a huge choice there of government, and I'm not going to predict quite how it's going to pan out, but I think that gives you an idea that there'll be lots of discussions going on and considerations going on between ministers and officials in the next few months, looking at all those options and what they think fits best for the politics here, which of course is the key driver. Now, in terms of the actual consenting process for the runway itself, we've got basically two choices here, as you've been hearing and reading, the DCO process and the hybrid bill process, and they are quite different. And I'm going to come back and tease out some of these differences later in the next few minutes, but they are quite different in that on the left-hand side, the DCO process is one that is basically run by the Planning Inspectorate on behalf of the Department for Transport. It's driven by the promoter, Heathrow Airport, and it's a very prescribed and very onerous process, particularly legal obligations of consultation and when the application is submitted, a very, very intensive examination process. Less politicised, perhaps easier for the public to engage in, whereas the bill process is, as you can imagine, much more politicised, Parliament directly in control, immune from legal challenge by and large, and however, no programme certainty. So those are the two options in outline. And of course, both need the government to take action. The DCO process would only really be a runner in this case if the government, first of all, put in place a national policy statement, in effect saying, yes, we've received the Davis Commission report, we agree with it, and this is what we want to see brought forward by the airport in terms of a project, and this is the mitigation we want to see included in the proposal for us then to deal with under the DCO process. So that NPS itself, that national policy statement itself, following in the wake of NPSs for nuclear, for example, and other forms of energy, would be prepared and consulted on and then approved by Parliament over a 2-year process. The hybrid bill route, of course, is one that isn't run by Heathrow Airport. It would be run by the government and obviously requires parliamentary time and support. And I've set out the key hallmarks there of that process. It's a fairly new process, been up and running since 2010, never been used for an airport yet. And it's basically a process where major infrastructure of national significance can be approved through a process not involving Parliament, but one level down, after no longer a public inquiry, but after a process lasting no more than 16 to 18 months after the application's been put in, and largely involving a written examination of the project interspersed by hearings. And it's a process that's been used successfully now about 39 times in the last 5 years for projects as big as Hinkley Point C and the Thames Tideway Tunnel. So it's proven to work and it's getting better all the time, but it is a very intensive process for those of you who've been involved in it. I think you can vouch for that. And I've illustrated there the basic steps and timelines. The pre-submission period is quite flexible, and certainly for a scheme like Runway 3 would be circa 2 to 3 years. You've then got, once the application has been put in and has been accepted for examination, you've then got a largely fixed process leading to a decision within 16 to 18 months of the application being submitted. And that is a huge benefit compared with the old regime where projects, including Terminal 5, of course, took ages and ages to get consented, whereas promoters under this system know that 16 to 18 months after an application has been put in, the scheme will be decided upon and hopefully accepted. And the examination process, which is the bit in orange there, is hugely intensive, as I've just said. I'm currently going through it for the A14 improvement scheme in Cambridge. We had one of 9 deadlines expire at 12 o'clock this morning, and that involved us submitting another 2,000 pages of stuff into the process. And that was over about a 3-week period. And then we've got the next deadline coming up in about 3 to 4 weeks. So it's hugely intensive and onerous, but does have an end. It is finite, which I think is one of its attractions. And you're not meant to read that slide. That's from the Planning Inspectorate, and you can see those are all the it's a selection of the DCOs that have gone through the process since 2010. And you can see the orange on the left is all the pre-application work, all the consultation work. And then you can see the process operating from 0 on towards 500 days. And you can see that by and large, these projects are all getting consented within the 16 to 18 month process, which is a huge success. There are a few exceptions where they've been subject to special parliamentary procedure or judicial reviews, the bars coming out to the right. But by and large, you can see the pattern there firmly developed, which I think is one of the key successes of the regime. And this is Heathrow Airport's own current timeline. This was produced for a conference last week. And you can see there that the hope is that based on an early decision from government, the national policy statement would be approved by Parliament and designated at the end of 2017. The DCO could be submitted then about second quarter of 2018, and there you have the development consent granted towards the end of 2019, so before the end of this current Parliament. So that's Heathrow Airport's best guesstimate at the moment of a possible timeline for a DCO for runway 3. And just in summary, really, those therefore are the key considerations I've been talking about. This is the promoter and control, but sometimes it can feel quite lonely. I know Thames Water felt that a little bit on Thames Tideway Tunnel when they were under ambush from literally thousands of objectors. It's clearly less political, the Planning Inspectorate being an independent body. It's got extensive consultation and pre-app stages, which are very onerous. And it's also less flexible, both to actually change the application once you're in the process, and indeed once you've got your consent, there's not much wiggle room in terms of what you can then build. But certainty of delivery timescales is the key advantage. Turning then to the other alternative, hybrid bills. These have been around for many years in terms of the way that we've tended in this country to authorise the very major projects. So, for example, this was used for Channel Tunnel Rail Link, HS1, used for Crossrail, and is now being used for HS2. So it's like any other government bill, it's put through Parliament by the government, but because the bill relates to a particular locality and therefore includes things like compulsory purchase, those individuals who are specially and directly affected by it are allowed to turn up in Parliament, petition against the bill, and then have their issues heard by a specially convened select committee in the Commons. And then you get the same process in the Lords after that. It's been successful for those very large projects in delivering them. But of course, the hallmarks of the process are rather different to the DCO regime. Not least, of course, it's much more political and is subject to the will of Parliament. Same sort of process as you'll be familiar with any sort of government bill, except you have this crucial stage at 5 and 6 there, and then again at 10, where because the bill is hybrid, it's not just like a normal government bill, because it affects individuals through compulsory purchase and similar reasons. There's a special stage when individuals can turn up to Parliament and actually have their say. And we're currently seeing this working in connection with the High Speed 2 committee. There's a timeline for the HS2 Phase 1 bill. This is the bill for the railway from London up to the West Midlands. The bill was kicked off about 25th of November 2013 and then got second reading 28th, 29th of April 2014. I think that was the largest majority of any bill in the last Parliament. Petition deadline in the Commons, 23rd of May, and the committee has been sitting in the House of Commons ever since, obviously with recesses taken into account, and they produced an interim report before the last election. And you can see the numbers there. I've compared the numbers with the Crossrail Act. On the right-hand side, you've got a committee of 5 MPs that they are currently considering almost 2,000 petitions that were put in against the bill this time last year, in May last year rather. They've heard already more than 400 petitioners. They're currently chewing over the Chilterns part of the route. They've done lots of site visits. They've had so far 2 additional provisions, which is ways of changing the bill to suit what the committee thinks should be done to take into account arguments put to them by petitioners. And it's so far taken 19 months and counting, and I think royal assent will be either the end of 16 or early 17. The Crossrail bill took 40 months in total, so you're looking about a similar sort of time frame. for, I think, the HS2 bill compared with the Crossrail bill. And here are the key considerations you're probably picking up by now in terms of the very different political basis. It's also a different policy basis. You don't have to have a national policy statement, and of course we don't have a national policy statement for high-speed rail. It's much more flexible in terms of being able to change as the bill goes through, which is quite an advantage. Clearly, like any Act of Parliament, there's limited scope for legal challenge, which is, I think, a particular consideration for a third runway, given its controversy. It can include in the bill all sorts of other things, the kind of things I started off talking about at the beginning. Timelines are uncertain, and I think the other issue that will need careful consideration by the government in the context of Runway 3 is parliamentary capacity, because we are expecting at least 2 more hybrid bills for HS2. There'll be a Phase 2A, a Phase 2B bill. There may be a hybrid bill for Crossrail too, if that proceeds as planned by TfL. So more hybrid bills in the queue than we've had for a long, long time, and that will certainly be another consideration. So, the $64 million question, what are the deciding factors? And I've tried to sort of summarise them there. All the kind of factors I've been talking about will be being weighed up by the government if they are minded to proceed with the third runway. The hope is that in this announcement by the end of the year, we'll be told what is the plan in terms of taking the project forward, including through the consenting regime, whether it'll be a bill or a DCO.
Looking at these, which one would you say gives ordinary people, the public, who are affected the most say?
Well, I think that in terms of the public ability to engage in them, they are very different processes. The parliamentary process is not actually as intimidating as people might think, and I think the current HS2 Select Committee has shown that it's doing that job really well in terms of allowing ordinary people to come and actually say what they feel about the project. Whereas actually the Planning Act process can be, it's slightly sort of death by paper. You've got to navigate around complex websites, and so in a way I think the bill process it's less prescribed and less regulated, and there's far less procedure about it, which some may see as a disadvantage, but it's perhaps a more open process. It's less complex, therefore for some individuals who aren't used to paper trading, etc., it can be seen to be better.
Because I've sat in some of those committee meetings for HS2, and I think you're right. I really sensed from that committee they really wanted to hear what ordinary people had to say, and people were coming in with their folders and so on. But it is still someone with no legal experience quite often sitting there in an intimidating environment with DFT lawyers, or HS2 lawyers in this case. A lot of them told me they didn't find it an easy process. So is that going to cause problems, do you think?
Well, I think nothing is perfect, because I mean I've been to lots of hearings as part of the DCO examination 6 months, where they are formal events chaired by one or more planning inspectors, and again I think some people find those intimidating, and they're much more technically based, and yeah, many more acronyms and use of technical terms, whether to do with air quality or noise and things. So I think I can see both sides of the argument actually, and I think it depends who you are as to and what's the. If you're a pressure group, you might prefer the DCO process because you might feel you get a better hearing than if you're perhaps individuals who I think probably might feel they get a better hearing from a committee of Parliament.
Okay, are there any questions from the floor? I can see into the light. Yeah.
Steve Wilson from Mott MacDonald. The examples you gave of hybrid bills are all linear schemes, crossing multiple authority boundaries and so on, whereas Heathrow is a specific location. Is there any reason why hybrid bills have been used for the linear schemes, and does that give any hint as to?
Well, they haven't just been used for linear schemes. I mean, there was a hybrid bill for Cardiff Bay Barrage, for example. So if you look back, I think there have been about 20 hybrid bills in the last 40 years or so. That's a slight memory, but I think it's around that sort of number. And they've been used for all sorts of different projects, and not just publicly funded ones either. Because Parliament can do what Parliament wants to do, they're a very flexible form of authorisation, and so they don't have to be linear schemes at all.
You talked about the hybrid bill being more political. knowing what we do about Heathrow, do you think that puts it in greater danger?
Well, it's a good question, isn't it, whether the Prime Minister and his government would want to actually have a bill anywhere near Parliament on this sort of issue, or whether actually it is felt to be such a big issue that there's no alternative. I find it a genuinely impossible question to answer. That's not my skill, not being a politician, but you can see some who would sense an opportunity to, perhaps impose a defeat on the government if there's a bill in Parliament, given their slender majority in the Commons and lack of majority in the Lords. So again, I think it cuts both ways, and this will be, I think, a very finely balanced decision when the decision is made, if government's minded to proceed with this project in terms of what they think is the best route. And I think the Commission's report makes the point, doesn't it, that the government's got to decide what they think is the route that gives the greatest certainty and the greater certainty and the greater ability to attract the required investment, so this project can be delivered by 2030. And they make the point that that's really for government to discuss with the airport and with other stakeholders. So the Commission intentionally didn't make a recommendation on this, because I suspect they too found it quite hard to call.
Where does the legal system fit into this? I think the government are very worried about judicial reviews, things just clogging up the whole process, slowing it down, and they hope that it just goes away. That tends to be the way things work. Where does the planning process sit in terms of legal challenges?
Well, I mean, we've of course, whilst the conventional wisdom is that the courts are very loath to interfere with what goes on in Parliament, and we've seen that over the years. I mean, the HS2 project was, of course, judicially reviewed, but that was unsuccessful. But that was reviewed before the bill was, in effect, put into Parliament. I have no doubt that there will be judicial reviews of this project if the bill route is chosen, and I have no doubt there will be judicial reviews if the DCO route is chosen. And actually, the DCO route's shown itself so far. I said there have been almost 40 decisions now. There have been 7 judicial reviews so far, and only one's been successful. The Thames Tideway Tunnel scheme has now gone through its judicial reviews. It was in the Court of Appeal a couple of weeks ago and has thrown those off. So there will be judicial reviews either process. I think the difference perhaps is that whilst the bill process takes longer, it doesn't have that almost guaranteed length. Its propensity for judicial review is less. Therefore, you have to balance that with a shorter DCO period, but then a judicial review at the end of it. So yet another balancing act. But there is certainly plenty of scope for JR on both procedures.
Anthony Oliver from Infrastructure Intelligence. I suppose we all look back at Heathrow Terminal 5 as being the sort of situation we don't want to get into. Yet you do talk about Crossrail taking 40 months to get through its process and 19 months and counting for HS2. Are we really learning? Are we really improving the process? Or is it a question of, as Declan Collier mentioned earlier, that democracy just gets in the way?
Well, I think this new Planning Act process that's been in place since 2010 is a real break from the past. Gone are those long internal public inquiries where you've got lawyers slagging each other off. It's a much better process that, as you saw from the bar chart, is delivering consents, has delivered up to 39 consents in largely a uniform period of time. So it's much better, and I think that people don't feel any worse in terms of less public engagement. So I think that, Terminal 5, I think, took 10 years in total, and even for projects as complex as Crossrail that took, 3.5 years, 40 months. I think that for a project that size, that is probably inevitable.
So is the process that we've started with on this particular project of the Davies Commission, does that set the project up in a much better position, or is that just an additional, different bit of process? I think it's
a tremendous piece of work, because whether the government proceeds with a national policy statement as a precursor to going down the DCO route, or wants to put a bill in Parliament, the Davies Commission is a fantastic piece of work in terms of looking at all the options and alternatives and coming down very clearly, very firmly in favour of Heathrow, and that is a very potent piece of evidence for Heathrow and the government to use if they wish to. So I think it's whilst I said it's the end of the beginning and it's been a very long beginning, it's a very important beginning given the particular history of this whole issue and how big the nettle is.
One of the reasons the Terminal 5 inquiry was so long was because there was no national policy. In fact, the minister at the time described it as being the 1985 white paper was described as being a little yellow at the edges. So they spent a long time debating policy. My question, Robbie, is actually similar to one I asked in the previous session, which is about this wider package, including surface access improvements, not just at Heathrow, but at all the airports, and indeed the ability of those other airports to make use of their spare capacity. Do you see that being part of either a national policy statement, or is it one of those green, white, or whatever colour papers, or a command paper, or something like that?
Well, I think the government is going to want to address not just the Heathrow recommendation, but also the other recommendations for making better use of current capacity. So it's perfectly feasible, I think, to expect whatever colour paper comes out to deal with that wider dimension. And you can certainly envisage a national policy statement not just being confined to runway 3 and what the government wants to see in terms of runway 3 being brought forward with all the mitigation and other characteristics of the project. You could see it going further and dealing with the kind of planning policy considerations that it wants to see embedded in any proposals for improved surface access to other airports or other plans for the other airports, yeah.
Any more questions? Just quickly, there's always a sense that it's harder here than abroad. Is that true?
Well,
the French don't seem to have a problem building fast train lines, for example.
So it's often said, Richard, I've never been convinced myself that, we believe in free speech and everything that entails in this country. We believe in a process where, democratically kind of a process where people can have their say, and that's extremely important. I'm not an expert on the equivalent process in France or elsewhere in mainland Europe, but I think certainly the process we've got to now, whether under the Planning Act or indeed the modern incarnation of the hybrid build process, which has shown itself to be responsive and efficient, is as good as we can get, because we are dealing with hugely important and complex developments. It's only right that everyone should have their say, but in a sort of measured and appropriate and proportionate way.
Thank you.